Hello, it's Philip Taylor speaking from Richmond Green Chambers, and this morning I'm looking at one of the core subjects which you have for your law examinations. It's the law of contract. This is a particularly good book that I have come across from Routledge, which is a Taylor and Francis Group company. It's called Text, Cases and Materials in Contract Law. It's now in a third edition. It's been written by two people, Richard Stone and James Devenney. Now this is the book here. There's a little bit of the spine, and then you've got the back. Now you've got with this a companion website, and they show a little bit of what it looks like there. I'll talk about that in a minute. Let's look at the book first of all. It's a heavy book, 700 odd pages. Relatively short index, you can see there, not particularly large index. You've got remedies at the back as normal. You've got a lot of very interesting speeches. You get the cases and the speeches. Remember, this is text, cases and materials, so you're going to have a lot of case law. Contract is particularly interesting in that area as a core subject. That's the front, explaining what the book is all about. And then there's the first page. Then do have a look at the main preface, which will tell you what the purpose of the book is all about. There are 15 topic areas in the detailed contents. I'm not going to go through them. You've got tables of cases, which you can see there. Then you get into the main area itself of what the book is all about. As I say, the preface is very helpful. What you have got with each chapter is a little index at the front, which assists you trying to find things. It tells you, obviously starts off with an introduction. Says the classical law of contract. You've got extracts, of course, because it's got text, you've got academic content as well. And you've got a very substantial amount of useful information. Now, I mentioned earlier about the preface. That is the main preface there. I don't know whether they've got anything specific here about the companion website. It doesn't appear that they do, but they do on the back. So you need to go onto the internet and find the website itself. As I say, you've got the paragraph numbering at the sides. There aren't footnotes in this, but you've got a lot. When you have these areas like this one, which is shaded areas, they've actually got the speeches by the main judges. And that, of course, is one of the most important aspects of the book, because contract law is not as easy as some people think. If you look at Chitty on contracts, you'll find that that's really quite a difficult book to understand, but it is the main statement of law. This is taking actual extracts, and it's a very high quality publication from Routledge. And what I like about it is that the companion website is actually very up to date. So you don't have as much by way of new cases in the law of contract as you might have, say, in criminal law, evidence or tort. But you do need to know the standard cases, some of which are wonderful, like Mrs. Carlisle's case with the carbolic smoke ball, which is a classic in its own right. And do have a look at my review of that on the web. Now, Elizabeth, my wife, and I have written a review, and we've given it the title for Undergraduates and Graduates, an ideal study resource in contract law. And that's what this is, because it's to go with the other publications that Routledge produce, the Q&As, the revision books, the main textbooks and the law cards. Now, this is the third and the latest edition of a detailed, carefully researched and accessible text on contract law. It's published, as I say, by Routledge, and it's hefty yet a convenient single volume which brings together a wealth of commentary on contract law, supported by extracts from a wide range of research sources. And as the two authors, that's Richard Stone and James Devenney, explain, the book is composed of approximately 1/4 the author's commentaries and 3/4 cases and materials. Authors there being the academic commentators, not these two, the academic commentators of the on particular areas which may be quite difficult and need a bit of explaining, or areas for reform, or areas which academically could be important when it comes to, say, your examinations. The commentary, we think, is sufficiently detailed because you as a student can dip in and out of the cases and materials as you see fit. And just think, the two authors, each an acknowledged expert in this often complex area of law. It's not as simple, as I said, as you think. Contract can be a little bit more difficult than you think in terms of the concept. So do be careful. Don't make too many assumptions about the law of contract. What you've got here, though, is they've amassed an enormous amount of carefully selected research. So you don't have to, in other words, so to speak. This in itself, we feel, offers a rather advantageous head start for the diligent law student whose understanding of the law of contract can and should be considerably enhanced as a result, and whose study skills can be all the more finely honed. And it is a good study material, and it saves you fiddling around in the library a lot, because you've got a lot of stuff in one spot. It's a one-stop shop almost, if you like, for text and materials on contract law. Quote, "There are differing views as to what contract law is about." That's what the authors warn you. And their commentary is interspersed with explanatory and occasionally contradictory views from a variety of learned sources on the subject matter of contract law. Now, I'm not going to go into that, but do bear in mind things like mistake and misrepresentation, because you do get contradictory views. You've got conflicting case law as well. So that's just one example of the problems. The initial, by no means definitive conclusion to this book, in our view, is that while the promises given are central to the idea of contract, there are difficulties with it. And obviously that's the basic concept of things like you've got the offer and the acceptance, and you've got this doctrine of consideration, which is again something which I think some people do have problems grasping. So do think about what the promise is when you've got a contract, whether it's legally enforceable, there's an intention to create a legal relationship, and all that sort of stuff. So this erudite and carefully argued yet straightforward approach that they use here, it's followed more or less consistently throughout the book. It's fair to say it certainly holds the reader's attention, and I think they get the balance about right, because as I say, some of the earlier books were a little bit more difficult and actually quite hard going, frankly, but this isn't. The book has a dual aim: first, to provide a clear exposition of English contract law, and secondly, to encourage a critical approach to its diverse subject matter, which is robustly examined over a total of 15 chapters. The areas covered within the book's more than 700 pages include all the major aspects of contract, from forming the agreement and the contents of the contract to, for example, misrepresentation, mistake, duress, undue influence, illegality, remedies, and of course a lot more. You'll find the remedies right at the back. Always remember the remedy, because when you're doing a problem question and answering it, the remedy is something quite often the students miss, so do remember your remedies. There's a lot more, as I say. Each chapter begins with the introduction, which I've shown you to give you an index of what's in it, and it ends with a list of additional reading for further study and research, if that's what you want to do. The authors note that the volume is suitable to use alongside the Modern Law of Contract in a 10th edition now from 2013, and it's designed to supplement it, although either book can be used independently. I think you do need to have a general textbook to understand the principles, and then this gives you the very much greater detail that you're looking for. There's also a companion website which I've mentioned, which contains skills, advice and self-assessment resources to assist the student in his or her unrelenting quest for examination success. And of course the companion website is up to date, and there are good learning tools there which I think you'll find in terms of potential content that you need for your answers. The book is both an orderly and efficient study guide and a scholarly treatise, which makes an otherwise difficult subject easier for students in our view, and it obviously is good as a tool to understand how the system operates. Ideally every law student in our view should have a copy, and the law is stated as at the 1st of July 2013, I'm so sorry. Look at it again, there it is, that's the back bit, heavy as I say, 700 pages. Just to refresh your memory, just flick in. Contents here, implied terms, always a difficult area. You've got the Sale of Goods Act to look at, 1979. you're just lucky you've got the 1979 Act, because a few years ago we had to deal with the Victorian legislation on sale of goods, which was not easy to understand. Oh, there's another example of what you've got. I rather like the vase on the front page as well, having done one or two cases involving vases with our friends in the antique business where you can have some problems. Thank you to Richard Stone and James Devenney anyway for an excellent book. I love the law of contracts, great fun. It's very interesting for anybody to look at because we enter a contract when we do almost anything today, so it's really relevant to every person on the planet. Thank you so much. Bye bye.